Didn't I tell y'all that? Look, I know people don't. I know people don't listen to me. I'm nobody. I recognize that I'm nobody. It's been a minute. It's been a long time. I shouldn't have left you without a dope beat to step two. Step two, step two, step two. We get step two. Step two. What's going on, y'all? This is Structure Mike. It's been a minute since I went streaming. I was on a project doing some things. I'm back. This isn't anything to be excited about because you're still talking about the loss of lives and all that other stuff. But look, those of y'all who've been following me for a long time, didn't y'all hear me say that it was a high likelihood that QUADAJAH Holly Johnson was going to be granted pretrial release? Didn't I tell you that? Now some of y'all like, but you wishy-washy. Well, you don't understand anything about the law. The law looks at things from both sides. The law looks at things from both sides. My job is not to appeal to whether or not you like me or whether or not you think I'm for QUADAJAH Holly Johnson or against her, for Romika Meeks Blackman or against her. My job is not to care about how you interpret things. My job is just to, interpret things based on my knowledge, skill, ability, competence, capacity, agency, access, all that given stuff. So for those of you all who are like, Mike, what are you talking about? We are talking about the issue that occurred between QUADAJAH Holly Johnson and Romika Meeks Blackman on September 8th, 2025, in the shooting death of Romika Meeks Blackman by QUADAJAH Holly Johnson. She was charged in, I don't know what that even means. She was charged in the shooting death of Romika Meeks Blackman on 20 West Cermak in the city of Chicago. She was arrested in September and detained for 48 hours and then was subsequently released for whatever reason in Cook County, Illinois, which is the county seat of the city of Chicago. They apparently didn't have enough information to be able to charge her with first-degree murder under Chapter 720 Illinois Compiled Statutes Act 5, Section 9-1. So after she was released from custody, she was then, I don't want to say sent home, but she was released, where then December 8th, I believe that was the date. Let me go back to it. I got the filing right here. I'm going to bring you up to speed. This is the decision. But I'm going to also bring you up to speed as to the, not the argument, but the procedural facts. Let me kind of switch to this real quick. By the way, those of you all like, comment, share. I can't even really see the Facebook comments. I think I can, but I can't see them. I'm going to go live later on and talk about it again. But like, comment, share, all this stuff. Okay. So that way we can get more out there. Let me see. Okay. December 4th. There we go, Latricia. What's going on? Like, comment, share, all this other stuff. So December 3rd, 2025, Miss QUADAJAH Holly Johnson was arrested by the Chicago Police Department because of the Cook County State's Attorney decided to file charges for first-degree murder against her. In fact, it was December 3rd. Yes, it was December 3rd. All right, so I'm going to go on ahead, and as you can see, I have on the screen right here, let me blow it up. I have on the screen the opinion of the appellate court. The opinion of the appellate court. And I'm going to go on ahead and read that. Go ahead, kind of eliminate some of these extra windows I do not need. Okay, great, great, great. No, I don't need to save that. Okay, need to save that. Got it. Okay, so we got the opinion of the court right here. Blow it up. Oh, I should have kept it small so you all can see it. Okay, good. So you all can see it. Got it. All right. Let me see if I can do that. Just want to be, you want to be able to see it. Oh no. The more I expand that window, you more you can. Okay, let it go. Okay. All right. So can you all see that? Can you all see that? Type in the comments. Let me make sure you all can see that. Let me hide this current comment. I want to make sure you all can see that. So we're reading things together because I don't want anybody to say, oh my God, you're being biased, blah, 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 blah. Got it. I mean, you got your own opinion. That's fine. You're entitled to it. So let's go on ahead and read the opinion of the court. First of all, this is in the appellate court of, and by the way, I've already read the opinion. I've already heard the opinion, things like that. And let's go on ahead and go over it. By the way, I will answer your questions regarding classes and all that other great stuff. Okay. So this is in the fifth division. Hold on 1 minute. What are we doing? Oh, okay. Got that. Give me one. All right, technical difficulty. All right, here we go. So this is in the fifth division in the appellate court of Illinois, the first judicial district, under docket number 1-26-0116, B as in boy, people of the state of Illinois versus QUADAJAH, which we now know as Holly Johnson. Justice Mikba delivered the opinion or the judgment of the court with opinion. Justice Odin Johnson concurred with opinion and judgment, and presiding Justice Mitchell dissented. We will not be reading the dissenting opinion. Yes, Chanel, I can see the Facebook comments. Yes, I can. Here we go. The opinion. So defendant QUADAJAH Holly Johnson appeals from the circuit court's order granting the state's petition to detain her before trial pursuant to section 110-6.1 of the Code of Criminal Procedure of 1963. There was a subsequent amendment commonly known as the Pretrial Fairness Act. We reverse the circuit court's detention order and remand to that court to consider conditions for Miss Johnson's pretrial relief. What does that mean? Get out the way. What does that mean? That means she will be released from pretrial detention. Now, those of you all who followed me, you know that I said Ari made some great arguments for why she should have been released pending the outcome of this trial, that people have been convicted or have been alleged to have done far worse and have been given pretrial relief. So you know I already had this opinion if you've been following me. I'm not worried about the naysayers, right? So let's get to it. In the petition for relief she filed in the circuit court, Ms. Johnson argued that the state failed to establish by clear and convincing evidence, which this is the standard of proof. Okay. Those of y'all don't know, I am a criminal justice professor. I do teach this stuff. So there will be teaching throughout this. So I'm not just going to read it outright. You're more than welcome to go online and get your own understanding. So there are standards of proof, right? You've got the preponderance of the evidence, and then you've got the clear and convincing evidence, which is, over that, so to speak, right? But that's okay. And I'm going to address that too. You said, yeah, I remember you said it would go to appeal, but my recent post confused people. If you don't follow me, you don't know. That's what I do. I will muddy the waters to get more conversation and more engagement, because this case is not as clear as people would like to make it be. That's what makes this case so interesting. Now, the incident is not interesting. Excuse the expression that I'm about to say, but this is Nora, Ida, George, Adam violence. Read between the lines. That's exactly what this is. This is interpersonal problems in a dysfunctional community that does not understand how to have better relationships and be better for themselves. And then they intertwine, have children, have their own adverse childhood experiences. And when they can't solve problems, this becomes igone violence. Pig Latin, you know what it is. So ain't nothing special about this. But what makes this interesting is the evidence and the offers of proof and the lack of other, video, concrete evidence that makes this let's see where the court is going to go. So that's what makes this special, so to speak. So that's why it's interesting to me, because I want to see how it's going to turn out. It's a lot. But here we go. Ms. Johnson argued that the state failed to establish by clear and convincing evidence that the proof was evident or the presumption is great that she committed first-degree murder, which is the detainable offense she's charged with pursuant to 725 ILCS 5, section 110-6.1A15, which is that's the prong within the Pretrial Fairness Act, because it used to be bail. If it was bail, she probably would have made it, but it's not that anymore. We got pretrial fairness. So that she posed a real and present danger to individuals in the community and that no conditions could mitigate that threat. We agree with Ms. Justice Odin Johnson that it is not related. That Justice Johnson is not related to the defendant, QUADAJAH Holly Johnson. Now, you said, could the state respond? No. The state can't respond, not to this, because this is the judgment of the appellate court. Now, what they could do is they could try to appeal to the state Supreme Court, but I highly doubt that this is going to result in any change from the state Supreme Court. I don't think it's going to go that high. I don't think they're going to push the issue that high. They could, but I don't think they're going to do it. And I haven't seen them do it. It can happen though. So we agree with Ms. Johnson that the state failed to carry. So here we go. Let me go back and read this because I got distracted by this part right here. That's just to show that one of the justices is not related to QUADAJAH Johnson, because if that was a relation, she would have to recuse herself on that fact. So let me read this again. In the petition for relief she filed with the court, Ms. Johnson argued that the state failed to establish by clear and convincing evidence that the proof was evident or the presumption great that she committed first-degree murder, which is the detainable offense, and that she posed a real and present threat to individuals or the community, and that no conditions can mitigate that threat. We agree with Ms. Johnson that the state failed to carry its burden by showing that her release poses a significant threat and that she cannot be released pending trial with conditions. Now, I love their analysis. Let's get to it. Let me not delay. On December 3rd, this is the background of the case, and this is going to catch you all up. Go on ahead and share this. Here we go. We're going to go on ahead and, we're going to go on ahead and go to the background. So on December 3rd, 2025, Ms. Johnson was arrested and charged with 6 counts of first-degree murder pursuant to Chapter 720, Illinois Compiled Statutes Act 5, Section 9-1A1, 2, West 2024. So that's just the codification for first-degree murder under the Illinois Compiled Statutes, which in layman terms is Illinois law. And she was charged with 6 counts of first-degree murder for shooting and killing Romika Blackman several months earlier in September. The day after she was arrested, the state filed petition seeking Ms. Johnson's pretrial detention under the aforesaid statute 725 ILCS 5 110-6.1. The evidence that the state proffered at the hearing was that on September 8, 2025, Ms. Johnson was in a relationship with Carlos Smith, the father of her 6-month-old child, and the child she was pregnant with. Now, that pregnancy was subsequently after the fact. Mr. Smith was also the father of Miss Blackman's 6-year-old son. You all know him as Little Los. Before 8:30 a.m. on September 8th, Mr. Smith drove Miss Johnson and their baby from his home to Miss Johnson's car, which was parked nearby. The address 20 on or near 20th West Cermak. He double parked his car, and the two of them moved their 6-month-old from Mr. Smith's car, which was the black Mercedes SUV, to the car seat in Ms. Johnson's car, which was I believe another black car sedan. Ms. Blackman had just dropped her child off at a school across the street, which was National Teachers Academy on 55 West Cermak, which was on the opposite side of the street. Those of you all who follow me, you saw me do that video when I drove from that location to the location where it occurred. It's not that close, but not that far. You see what I'm saying? So, and I'm going to answer some of your questions. So keep sharing. Okay, here we go. Ms. Blackman had just dropped her child off at a school across the street. Shortly after, Ms. Johnson secured her child in the back seat of the car. Ms. Blackman drove past Ms. Johnson's car, made an immediate U-turn and stopped with her car double parked just behind Ms. Johnson's car. This put Ms. Johnson's car in between Miss Blackman's and Mr. Smith's. Come on now. Get out the way. This is what happens when you're doing stuff through Adobe. Sorry, I just want to read it from Adobe. I ain't want to read it from the website. So you're going to see that from time to time, right? But get out the way. Move. Sorry. Oh, that is something else. All right, let me get back to that screen. But that right there, that's a fact. That's the background. That's what was proffered, right? This doesn't make Romika look good. I don't care what you all say. This does not paint Romika in the best picture. It does not. I said that from the beginning. It was going to be a fact of this case that goes in favor of QUADAJAH. It's going to go in favor. Your hood logic doesn't always play well in the courts. People versus Rodriguez. Okay. Learn the law. Here we go. Ms. Blackman got out of her car. Hello. And there were words exchanged between her and Ms. Johnson. This confrontation was observed at various points by a number of witnesses, including Mr. Smith. According to the state, witnesses would describe how Mr. Smith stood between the women and pushed Ms. Johnson away from Ms. Blackman, who was standing in the open driver's side door of her vehicle. So we're not going to sit here and say that he did not do anything to QUADAJAH. According to the state, witnesses would describe how Mr. Smith stood between the women and pushed QUADAJAH away from Ms. Blackman. So apparently that was something that was not proffered in the state's proper verbally, but that was something that was offered later on. Okay. So the state reported that the evidence would show that one witness called 911. Hey, let's go. I'm going to read the comments. Give me a minute. According to the state, witnesses would describe how Mr. Smith stood between the women and pushed Ms. Johnson away from Ms. Blackman, who was standing in the open driver's side door of her vehicle, right? The state reported that evidence would show that one witness called 911 to report a fight between the two women and described observing Mr. Smith repeatedly pushing the door of Ms. Blackman's car shut, hitting her with it. The witness testimony proffered by the state was that Ms. Blackman then got into her vehicle and Ms. Johnson approached, threatening Ms. Blackman. Now, that was not a wise idea. That was not. That's why I said, don't get me for or against either side. Both of them, N-I-G-G-A, shit. Nick shit. Okay? Both of them. You got to have some accountability for that, QUADAJAH. Moving on. Here we go. The witness testimony proffered by the state is that Ms. Blackman then got into her vehicle and Ms. Johnson approached, threatening Ms. Blackman. Okay. Ms. Blackman got back out of the car. Not smart at all. Ms. Blackman got back out of the car and Mr. Smith placed her in a chokehold. Right. Ms. Blackman tried to break free with her hand in the air. Ms. Johnson threatened to shoot Ms. Blackman and retrieved a gun from her vehicle. You already know how I feel about that. All right. Ms. Blackman broke free from Mr. Smith and stepped backwards. According to the state's proffer, that was the point at which Ms. Johnson shot Ms. Blackman several times. According to the state, one witness reported that after Ms. Johnson shot Ms. Blackman, Ms. Johnson and Mr. Smith celebrated with a fist bump. Now, that's according to the state. One witness reported. There's no offer of proof to show that that is even in fact true. Okay. So here we go. Defense counsel argued that Ms. Blackman was the aggressor and that Ms. Johnson acted in self-defense. Defense counsel advised the circuit court that Ms. Johnson had sought a stalking no contact order against Ms. Blackman in December of 2024 because Ms. Blackman was repeatedly calling and text messaging her and her family members and commenting on her social media in a threatening manner. Defense counsel provided the state and the court with a transcript of the hearing held regarding that no contact order in June of 2025 and explained that Ms. Blackman threatened Ms. Johnson directly by text until Ms. Johnson blocked her number, and then Ms. Blackman sent threatening text messages to others, including Ms. Johnson's grandmother. in which she said that she was going to kill Ms. Johnson. Ms. Blackman was present at that June 2025 hearing on the no contact order, but did not make a subsequent appearance, and a default order of protection was issued on July 14, 2025. Counsel for Ms. Johnson argued that the witnesses at the scene told police that after Ms. Blackman got out of the headlock, she rushed at Ms. Johnson's car with the 6-month-old baby inside, and that was when Ms. Johnson shot her. Now, I'd like to see an offer of proof of that, because I didn't hear that at all. I didn't hear that at all in the doggone evidence. I want to see that. You see why the trial is getting interesting? Do you see why the trial is getting interesting? Because now we got people who saying, well, after she got out the headlock, she rushed Ms. Johnson's car with a 6-month-old baby inside. That's why I want to see the trial. I want to see the offers of proof. I want to see what's going to be allowed, because this is new. All right, here we go. Defense counsel also argued that Ms. Blackman had boxed in Ms. Johnson's car by pulling beside her when Mr. Smith's car was in front of hers, preventing her from leaving. If in fact that's true, I want to see the evidence, the crime scene photos that show, well, there's more. Here we go. On the issue of whether Ms. Johnson posed a threat to the community. By those of y'all who are reading, I'm just going to highlight where we're at. We're right here. Here we go. On the issue of whether Ms. Johnson posed a threat to the community, defense counsel emphasized that except for a speeding ticket and a misdemeanor retail theft conviction for which she received supervision, Ms. Johnson had no criminal background. This is true. I did the research. Ms. Johnson had a valid firearm owner's identification card and a concealed carry license, which you will see the appellate court liked. Here we go. She ran her own eyelash business, okay? Volunteered in the community and had just been accepted into a program to become a dental assistant. Ms. Johnson was also the mother of a young baby and had just become pregnant with a second child. You will find later these are facts in the case that are going to be considered pursuant to previous court precedents. Let's continue. Counsel underscored that Ms. Johnson had sought to obtain a protective order against Ms. Blackman, that she stayed on scene and waited for the police, that she cooperated with them, and that the state waited almost 3 months until December 3rd, 2024. Was it 2024? Whatever. That was 2025. Whatever. To arrest her. The court granted the state's petition for pretrial detention. On December 22nd, that's what I thought it was, 2025, whatever. On December 22nd, 2025, Ms. Johnson filed a motion for relief pursuant to Illinois Supreme Court Rule 604H. On January 7, 2026, Ms. Johnson filed an amended motion. At the hearing on the motion, the defense counsel provided the court with several exhibits. Jesus, I got that doggone thing. That was, Ari kicked ass on that one. I ain't gonna even hold you. Ari kicked ass. She did. Here we go. At a hearing on the motion, defense counsel provided the court with several exhibits, which are also part of the record on appeal. Defense counsel argued that the video footage showed that the state's witnesses could not have seen nor heard as much of the incident as they claimed, and that particularly witness 3, who was the only witness to report the fist bump, was not in a position to have seen Ms. Johnson after the shooting and did not report this alleged fist bump to the police when she spoke to them initially. She did provide that as an offer of proof, and even proved, I think she was on the bus at the time that this occurred. I'm looking at 162 people, but I'm looking at 12 likes. Can y'all go on ahead and hit that like button? You ain't got to subscribe, but hit that like button so we can get more people in this conversation. I'm not going to hold you. I know you're at work. Don't you get fired watching this. Don't you get fired watching this. You ain't going to be able to lie to me. Don't you get fired watching this. Go on ahead and hit the like, love button, whatever your emoticon is. Go on ahead and knock that out. Smash it. I got 164, 65 people watching at 21. Come on, y'all. I ain't asking for no cash apps and none of that stuff. If you send it, cool, because I'm also live on YouTube, whatever. Go on ahead and knock that out. Go ahead and share this, because this is a self-defense case. And as a force science analyst, I'm a subject matter expert in this space, qualified to talk about it. Criminal justice professor, all that given stuff. Okay, moving on. Here we go. Defense counsel also advised the court that Mr. Smith had reported to the police that Ms. Blackman approached Ms. Johnson, threatened her, and then swung at her. He also reported that Ms. Blackman told Ms. Johnson, "I told you I was going to catch you," and that Ms. Johnson told Ms. Blackman, "Leave me alone." Defense counsel pointed to video evidence that showed Ms. Johnson with her hair disheveled when the police arrived on scene, looking as if she had been attacked. At the hearing on her motion, defense counsel provided the court with the recording of a 911 call that was made regarding this confrontation from an anonymous caller that reported that two women were fighting and that Ms. Blackman was the aggressor. The state argued that video, and all this stuff is going to be officer proof that are going to be showed at court. We're going to have, yeah, hey, I got to put your comment up there, Latricia. I got to put it up there. Here we go. Ari debunked witness 3 so much, and that's still the state's lead witness. That's why I said this trial is going to be so interesting. Hold on, y'all. Look at your comments in a minute. Here we go. The state argued, and we're right here if we're reading. We're on line 18, okay? Here we go. The state argued that video footage from the officer's body-worn camera after the shooting showed that Ms. Johnson's car had room to drive away. Defense counsel countered that her office had been contacted by an additional witness who saw Mr. Smith start moving his car, and that's when Ms. Blackman charged at and attacked Ms. Johnson, and Ms. Johnson shot her. Counsel argued that based on witness testimony, until Mr. Smith moved his car, Ms. Johnson could not have driven away. This is what makes this case so interesting, because we got a witness who suddenly popped up and said this, but how convincing is this witness? Is the state going to be able to attack this witness? What's the credibility of this witness? This is why this case is so interesting, because we do not have video concrete evidence that supports people's statements. This is like the worst place to have done this in, because you got no extra video evidence, no pod cameras, you got nothing. So this is going to be interesting to see who the courts believe. Johnny Cochran said it best. Evidence does not win the day. Juries like stories. Our job is to tell our story better than the other side tells theirs. If you don't know who Johnny Cochran is, he's the famous attorney who was the attorney for O.J. Simpson in the matter of people of the state of California versus Orenthal James Simpson for the murder of Nicole Brown Simpson, his ex-wife, and her friend, or the butler at the restaurant they were at, Mezzaluna, Ron Goldman, right? You got to look, some of us are legal nerds, okay? Now, I am one such person. Let's get back to it. Here we go. So we're on line 19 right here. Here we go. Or paragraph 19. At the hearing on Ms. Johnson's motion for relief, the state reiterated the proffer that it made at the initial detention hearing. The state also noted that the default order of protection was never served on Ms. Blackman. So while she knew Ms. Johnson was seeking an order of protection, she may not have known that one had been entered when she stopped her car and approached Ms. Johnson, which would have violated this order. That is a fact. That is a fact. That is a fact that she didn't know that the default order was granted, because that is the word, default. It is a default order after you fail to show, and you still, as the petitioner, have proof of that you have to be able to provide additional evidence to show that you need a plenary stalking no contact order, which follows an emergency stalking no contact order. You still have proof of. After they're proof of, because you're not there, if the judge believes that enough evidence exists to provide you this plenary stalking no contact order, they will grant it after the end of your proof of, right? And proof of just means, well, the person isn't here. You still have to prove that you still have need for this. That's all proof of really means. Okay, so let's continue. The state also noted, we're right here, you all. Okay, get out of here. The state also noted that an additional witness not included in the previous proffer would support the state's characterization that Ms. Johnson was the aggressor. Can't wait to read that. Here we go. The court denied Ms. Johnson's motion for relief. This was in the initial. It noted that Ms. Johnson was alleged to have shot Ms. Blackman in broad daylight near a school. The court emphasized, except for Mr. Smith, whom it did not believe was a, quote, independent witness, which I got opinions on that too. None of the other proffered witnesses have reported seeing Miss Blackman ever strike Miss Johnson, and that they were all consistent in saying Ms. Blackman appeared to be unarmed throughout the incident. The court stated that it recognized Ms. Johnson, quote, seemed to have led a law-abiding life, end quote. But the facts of the incident nevertheless indicated that she posed a real and present threat to the eyewitnesses and to the community at large, which no conditions mitigate. Ms. Johnson filed a notice of appeal on January 8th, 2026. Here's the second section, jurisdiction. Okay, y'all go ahead and like this some more. Like this some more. Let's go ahead and talk. Like this some more, please. Oh, here we go. Somebody doesn't understand how reading works. Don't just take bits and pieces of the Bible to fit your narrative. It also talks about self-defense and bullying. Okay, let me back up. I don't know if you were saying that. I probably misinterpreted that. Let me get back to reading. I'm sorry, Reed. I'm going to hold myself accountable. I might have misinterpreted what you said. Let me get back to reading because, yeah, moving on. Jurisdiction. Ms. Johnson's petition for relief was denied on January 8, 2026, and she timely filed a notice of appeal that same day. We, the Appellate Court of Illinois, the First District, have jurisdiction over this appeal under Section 110-6.1J of the Code, pursuant to Public Act 104-417, Section 1075, effective codification. Here we go. And Supreme Court Rule 604H, okay, which governs appeals from orders denying pretrial release of a criminal defendant. Here we go. Analysis. Boy, I love all this. I love it when the courts talk about stuff. Here we go. Under the Pretrial Fairness Act, quote, all defendants shall be presumed eligible for pretrial release. To overcome this presumption, the state must seek pretrial detention by filing a timely verified appeal or petition pursuant to 725 ILCS 5 110-6.1A, subsection C. Once the state has filed a petition, the defendant can be detained pending trial only where the state shows by clear and convincing evidence. Remember, I said that's the standard before after a preponderance of the evidence, right? So you've got reasonable suspicion, you've got probable cause, you've got clear and convincing, you got a preponderance of the evidence, then you've got clear and convincing. Above clear and convincing is proof beyond a reasonable doubt. That's the next standard of evidence, but we're not at that stage in the trial. Let's go. Once the state, we're back here, paragraph 26, okay? Once the state has filed a petition, a defendant can be detained pending trial only where the state shows by clear and convincing evidence that, one, the proof is evident or the presumption is great that the defendant committed a qualifying offense. Two, based on the facts of the case, the defendant, quote, poses a real and present threat to the safety of any person or persons or the community, end quote. And that three, quote, no condition or combination of conditions, end quote, provided in section 110-10 B of the code can mitigate, which means can lessen that fact or deal with the possibility that she could pose a threat, either to the safety risk or the defendant's willful flight from prosecution, okay? Whereas in this case, the circuit court made its detention decision without hearing live testimony, we are not bound by that court's factual findings, and we should make our own de novo determination. De novo is just Latin for from the beginning, right? We should make our own de novo determination as to whether the state has met its burden on each of the statute's three requirements pursuant to the Illinois Supreme Court case of People versus Morgan, 2025, Illinois 130626. Okay. If you all don't understand anything about the law, under the doctrine of what's called stare decisis, stare decisis is Latin for to stay the decision of the previous courts or the previous decision, provided it's applicable to the jurisdiction hearing it. The Illinois Supreme Court trumps the Illinois Appellate Court, and this is a decision for which they are to stay that decision. Okay, so let's get back to it. Paragraph 28, here we are. The Pretrial Fairness Act presumes that pretrial release is available for all charged crimes, including murder. See People versus Robinson, 2025, Illinois Appellate, 2nd District, 250123U, reversing pretrial detention and calling the suggestion that a murder defendant poses a threat to witnesses pure speculation, where there were no threats or contact of any kind between the defendant and witnesses during the 15-month period between the offense and arrest. I told you they are going to use previous cases. They are going to use previous cases. I told you this ain't nothing special. Stuff like this has happened before. Sorry, sinuses, excuse me. All right, here we go. I can't control that. I mean, I can't, but we're here. It's live. Moving on. People v. Thomas, 2025, Illinois Appellate, 4th District. Okay, or that could be 4th. 251082U, caretaker who knowingly administered a lethal dose of medication to a child to be released because conditions could mitigate the very specific nature of the danger she posed. In other words, don't be around kids. Don't be around kids. That's it. Can't possess weapons. Don't be around kids. But you're not posing a threat to all kids. This is a specific circumstance. Here we go. People versus McCann, 2024, Illinois Appellate, 1st, 240-892U. Defendant accused of shooting her former lover at close range under disputed circumstances did not pose a significant threat to anyone else. Told you, not special violence, just violence. You get what I ain't want to say because you get what I'm saying, right? People versus McDonald, 2024, Illinois Appellate, 1st, 232-414. Defendant accused of shaking his baby to death, entitled to release where there were no other children he would be responsible for. Stare decisis, right? As these cases reflect, even in murder cases, a criminal defendant is to be released pending trial unless the state has shown that the charged defendant poses a real and present threat to the safety of any person or to the community, that no such condition could mitigate the safety risk. Because we find that the state failed to carry its burden by making this showing as to Ms. Johnson, we remand to the court to consider the appropriate conditions of release. So what remand to the court to consider the appropriate conditions of release means, they're sending it back down to the court to say, release her. Consider these conditions. You can't detain her. We've got previous cases where people who have been charged with way worse or its equivalent have been released given conditions. Consider conditions. We're not just going to lock her up. And I'm going to explain to you. Come on, stay here, because you're in a real class. I'm going to explain to you about the politics of the judiciary. I'm going to explain to you about the politics of the judiciary because you don't understand that at the trial court, these judges are also politicians. You don't really see people. Well, yeah, there are judges who do try to run for appellate seats, but there are also justices who are appointed to the appellate court by the Illinois Supreme Court. See, when you don't understand the politics of the players in the judiciary, you may not understand what motivates their decisions. I do. You see what I'm saying? So here we go. Let's go. All right, we're on paragraph 30. The specific factors that the court are directed to consider in assessing whether a defendant awaiting trial poses a threat are as follows. Number 1, Brooklyn, I'm in Chicago. I'll give you that information shortly, okay? Number 1, the nature and circumstances of any offense charge, including whether the offense is a crime of violence involving a weapon or a sex offense. Number 2, the history and characteristics of the defendant. Let me make sure you saw. Okay, you can still see it on the screen. Good. The history and characteristics of the defendant, including A, any evidence of the defendant's prior criminal history indicative of violent, abusive, or assaultive behavior, or the lack of such behavior. Such evidence may include testimony or documents received in juvenile proceedings, criminal, quasi-criminal, civil commitment, domestic relations, or other proceedings. We can have a long conversation on this. Let's keep going. 3, Any evidence of the defendant's psychological, psychiatric, or other similar social history, which tends to be indicative, which tends to indicate a violent, abusive, or assaultive nature, or the lack of any such history. Number three, identity of any person or persons whose safety the defendant is believed to pose a threat and the nature of the threat. Four, any statements made by or attributed to the defendant together with the circumstances surrounding them. Number five, the age and physical condition of the defendant. You can't omit that, right? Number six, the age and physical condition of the victim or any complaining witnesses. Number seven, whether the defendant is known to possess or have access to any weapon or weapons. Number eight, whether at the time of the current offense or any other offense or arrest, the defendant was on probation, parole, aftercare release, which is for juveniles, mandatory supervised release, that's called adult parole, or release from custody pending trial, which Holly will soon be on. Sentencing, appeal, or completion of sentence for an offense under federal or state law, or any other factors, including those listed in Section 110-5 under 725 ILCS 5 110-6.1G. Here we go. We look first under the statute to the nature and circumstances of the crime. While Ms. Johnson has been charged with an extremely serious and violent crime, this alleged crime was the culmination of a very personal and specific controversy. Yeah. Very extreme, serious, and violent crime. It's a very personal and specific. Here we go. You're not going to like this. There are undisputed facts about this confrontation that undermine any claim that Ms. Johnson remains a danger to the community. It is undisputed that Ms. Johnson did not seek out this confrontation. Fact. Rather, the victim confronted her. Fact. It is also not disputed that prior to this confrontation, Ms. Johnson sought and obtained a protective order, a legal and appropriate path for avoiding any violent confrontation. Fact. It is undisputed that Ms. Johnson remained at the scene and cooperated with police. Fact, even though she should have not have talked to them and said, well, I got concealed to carry. You should have shut the... All right, you know what I said. And it is undisputed that Ms. Johnson had both a FOID card and a concealed carry license. Fact. All those are facts. Indisputable. Indisputed. Indisputed. You can't dispute any of those. Here we go. In many murder cases, we're on paragraph 32. Focus your eyes. Here we go. In many murder cases, the nature of the crime itself provides strong evidence that the defendant poses a danger to the community or to other specific people. In a case involving a murder incidental to a violent crime, gang activity, domestic violence, a mental health crisis, or a random act, it is relatively a straightforward line, bright line rule, from the state's proffer of the expected trial evidence to a showing that the defendant is a danger to the community. However, this case is different because the alleged crime grows directly out of a relationship between these two women. The fact that Ms. Johnson sought and received a no-contact order against Ms. Blackman underscores the isolated nature of this conflict. Also in this case, the fact that this defendant had a history of adhering to all legal requirements, and the fact that there is nothing in her background to suggest any propensity for violent, abusive, or assaultive behavior undermine any claim that her release would pose a threat to others. We look next into the history and the characteristics of Ms. Johnson herself. Her only criminal history is for a violent or non-violent misdemeanor. The state presented no evidence to suggest that Ms. Johnson had a mental health history or a social history that reflects a danger to the community. Ms. Johnson's physical condition is that she's pregnant. Now, while her pregnancy certainly does not preclude violent actions on her part, its progression may well limit her ability to engage in them. That's a fact. Okay. What are we talking about? You say I'm a little late. What are we talking about? I don't know what that means. Here we go. While we also find it persuasive that Ms. Johnson remained at the scene until police arrived and fully cooperated with them. In addition, bro, watch this bomb drop. If you follow me, you know I already said this. In addition, although these events all occurred on September 8th, 2025, Ms. Johnson was not arrested until December 3rd, 2025. Thus, for almost 3 months, she remained out of custody, but in touch with police as they continue to investigate this case. This fact also demonstrates that she not only posed then and will likely not pose, if released, a threat to the other witnesses involved, as the circuit court suggested she might. I'm going to tell you this. In Cook County, it does not take long for them to file charges under 720 ILCS 5, Section 9-1. It is nothing to get a first-degree murder charge and then subsequent indictment prior to a preliminary hearing. The fact that 48 hours they released her, and then 3 months later, they arrested her and she did. Y'all watch the first 48. Y'all know people who usually take the life of another person. Where they go to? Atlanta. Where they go to? Texas. Where they go to? Some other place. Holly stayed here. You follow me. I told you that was going to be something they were going to consider. You can't eliminate it. It's a major fact of the case. If that proof isn't evident or the presumption is great that she's going to comply, let's go. Paragraph 35. We also find this to be a case where conditions could be imposed that would mitigate any possible threat, and we remand to the circuit court for consideration of those conditions. Here we go. And as a concealed carry instructor, this is near and dear to my heart. You're going to learn today. Here we go. Very significant to us is the fact that Ms. Johnson had both a FOID card and a concealed carry license for the gun she used. This suggests that she would adhere to a court order banning her possession or use of any firearms, which would surely be a condition of her release. For those defendants who have been arrested and are awaiting trial for offenses involving illegal gun possession, a ban on the possession of firearms is often viewed as an ineffectual condition of release. In other words, we could impose the ban, but they gonna carry anyway. But that's not the case with QUADAJAH Johnson, right? Here we go. However, for Ms. Johnson, who it appears from the record has never owned a gun illegally, this is a condition that could and should mitigate strongly against any threat. Finally, we note that there is an additional consideration in this case because if the detention order remains in place, Ms. Johnson could have to give birth while in jail. Before the Pretrial Fairness Act was enacted, a separate 2019 provision in the bail statute required a hearing before any pretrial defendant was required to give birth in custody, 725 ILCS Act 5, Section 110-5.2. That provision currently provides that, quote, it is the policy of this state that a pretrial detainee shall not be required to deliver a child while in custody, absent a finding by the court that continued pretrial custody is necessary to alleviate a real and present threat to the safety of any person or persons or the community under 725 ILCS 5, 110-5.2. The trial court, citing this statute or this section of the statute, suggested that Ms. Johnson's pregnancy would require renewed consideration of whether Ms. Johnson should remain in custody as her due date approaches. However, for the reasons outlined above, we believe that Ms. Johnson should be released sooner rather than later to prepare for and give birth to her baby and to prepare with her counsel for trial. Our dissenting colleague, and this is where I love how they kick back the dissenting colleague because let's go. Let me read it. Paragraph 38, feast your eyeballs. Here we go. Our dissenting colleague suggests that we fail to appreciate the dangerous situation created by Ms. Johnson firing shots on a public street with children around when she shot Ms. Blackman on September 8th of last year. Of course we do, and that may well be an appropriate consideration at trial, but that is not the question now. Rather than that question under the Pretrial Fairness Act is whether Ms. Johnson would be such an ongoing threat to the public safety that she must remain in custody while she awaits trial. And I would furthermore argue, this is just me talking here, I would furthermore argue there were no children around. The children were in school. She was on a public street. Shots get fired on public streets all the time. In fact, I would furthermore argue that Romika Meeks Blackman should have thought about that before she approached QUADAJAH Johnson. She should have thought about that before she approached QUADAJAH Johnson, for QUADAJAH Johnson does not have a child who goes to National Teachers Academy at 55 West Cermak, but Romika Meeks Blackman has a child who went to National Teachers Academy at 55 West Cermak. And if anybody should be considered or should take into consideration what could happen to the children, it should be the one for whom has a child at that particular school and not the one who just gave birth to a 6-month-old child who's not even old enough to be in preschool. Daycare, yes, not preschool. Does that make sense? So if Romika Meeks Blackman didn't consider that, how sway should we throw that consideration upon the person who is alleged to have defended themselves? See, the only reason why I'm not a lawyer is because I didn't go to law school and get a law degree. But Your Honor, for the record, Mike Brown seeking leave to file my appearance on behalf of the defendant, QUADAJAH Holly Johnson, who stands before you in open court. We like to make an oral motion for discovery and set it down for discovery in the event that state can't tender discovery. Oh, I know how to try a case. You may not understand, I actually do have trial experience personally. Don't play with me. Moving on. All right, paragraph 39. Trial will also be the right time to choose between the competing narratives of the confrontation between Ms. Johnson and Ms. Blackman. The dissent paints Ms. Johnson as the clear aggressor, motivated by jealousy or anger at a romantic rival, than by fear for herself and her 6-month-old child. We have briefly laid out some of the contrary evidence in our recitation of the facts, and we recognize that it will be up to the trier of fact, not us, to decide if this was murder or self-defense. By the way, the trier of fact will be the jury. The judge is just a trier of the law. Well, pretty much holding triers of fact, judge of the, okay, whatever. I got to get my mind set on what that is. But the triers of fact will be the jury, okay? The person who holds it together will be the judge. All right, here we go. Finally, the dissent cites People versus Gage, 2026, Illinois Appellate First, 252-526U, and People v. Martinez, 2025, Illinois Appellate. By the way, these are all appellate cases. You're more than welcome to look them up. 250-298U as support for its suggestion that this court is asking the trial court to do the impossible in remanding to determine what conditions should be imposed upon Ms. Johnson's release to protect the community. Those cases are, of course, totally different. In those cases, Ms. Gage was already on pretrial release in another case when she was arrested in the case cited. That's not even relevant. That's not even relevant to the case at hand. Here we go. Those cases are, of course, totally different. Ms. Gage was already on pretrial release in another case when she was arrested in the case cited. Neither of these defendants waited for police, as Holly did, cooperated fully with them, and were released for several months following the shooting, as Holly did. These very different facts in Ms. Johnson's case suggest that she will fully comply with whatever conditions of release are imposed, including, but not limited to, possessing no firearms, a condition that we direct the court to include. So they do have the power of imposition or directing, okay? We trust that the trial court will be in the best position to decide which other conditions are feasible, fair, and protective. Oh, and she gonna need some protection. Y'all see what they tried to do to Carlos. Y'all see what they, family. And I'm not saying family because I'm related. I'm not related, but family. I know you watch it. Y'all better have y'all just better have plans in place. Yep. Moving on. All right, here we go. Conclusion. For the above reasons, we reverse the circuit court's order granting the petition for pretrial detention and remand, which means to send it back to them with directions to the circuit court to determine the conditions of Ms. Johnson's release. Reverse and remanded. I am not going to even read Presiding Justice Mitchell's dissenting opinion because even in the Supreme Court of the United States, when they read the order of the court, they don't read the dissenting opinion. They state who filed a dissenting opinion, and you're free to go look that up. So if the Supreme Court don't read it, I'm not going to read it because a dissenting opinion is pretty much just an on-the-record FU to the other judges. I mean, it is worth reading, but I'm just not going to read it. So what are your thoughts? Sound off in the comments. I want to see what your thoughts are. Hey, T Black, what's going on? Sound off in the comments. What are your thoughts? Those of you all who followed me, sound off in the comments. Didn't I tell you that Ari made some clear and convincing cases of people post the enactment of the Pretrial Fairness Act who did way more heinous stuff, still took the life of someone and were given pretrial release? Y'all just think this is a special case because it's involving the title of a mother. That is a coveted title, especially within the Black or African American community. Plenty of arguments behind that. Not going to go there. You already know my thoughts. And that's the only reason why it's getting so much attention. But I told you, now I'm going to be fair. I said in the beginning, I said, I don't know if I would have gotten Ari as a criminal defense attorney if I were facing murder. And I'm going to state my reasons why I said previously that I don't know if I would have gotten her. I stated that not because she's Black, not because she's a woman, but because I had not seen any previous cases where she took them to trial and won. Baby, I am following this case. Ari is kicking ass. Okay? Don't sit there and throw your bullshit on me. Ari is kicking ass in her stuff, and I love it. I am here for it. I said I would have gotten Sierra Norris. Why? Because Sierra Norris puts her wins on her. She publicizes those. Oh, she publicizes her wins. So when I see the proof is evident and the presumption is great that that Sierra is good at what she does, oh, she got storylines. But baby, Ari is showing through. Now, here we go. Yeah, you heard me at Plain Jane. I hadn't seen her do it before. So my assumption is without any proof that she's good at trial. I don't need, so let me give you some background. People versus OJ. I keep referencing that case because I study it so much. There's a difference between Robert Shapiro and a Johnny Cochran. Robert Shapiro is a type of litigant where he tries to knock out stuff before it even gets to court. He's a plea bargain attorney. Johnny Cochran is a trial attorney, takes it to trial and wins. That's who you want. You don't want just a person who can win battles. Now, don't get me wrong. I get it, right? You do want to try to take the case out in pretrial, but what if it doesn't succeed? How good are you going to be when this case goes before the triers of fact? Does that make sense? How good are you going to be when you have to make your opening arguments to the jury? Now, I see it now, Hassan. I see it. Ari got storylines too, and she posts her wins. I've been seeing it. I'm fair. Hey, say what you want to say about me. I'm fair. You may not think I'm fair, but I'm very fair. I see what I see. I say what I say until I see facts and circumstances that get me to change my opinion, and I change my opinion with proof to show. I'm fair. I'm fair. And now I see Ari been posting her wins. So, hey, I love this for Ari Williams. I love this for Ari Williams. I love it for her because now I'm seeing it. And I don't know. In fairness, I'm a very busy person. I do a lot. I teach. I got preschool and I teach concealed care. I teach a lot of different stuff. So I'm not seeing it. I'm not seeing it. But I'm glad I'm seeing it now. Man, she did her big one. And especially when I read hold on, let me share this screen. I'm going to show you how good Ari is. And this is in the, let me share this screen. Hold on. Now, this is it. Do I think she will do some time? Ooh. I don't know. Here we go. Here's some guesses. QUADAJAH does not. Okay, here we go. This is going to be argued from a self-defense claim. The baby has to be considered as a part of that. I don't know if she's going to walk entirely, but I do know if she does walk with a not guilty verdict, Ari is going to be among one of the popular attorneys, even more popular than she is, because she will have pulled out the unthinkable. Now, Jay said, what baby? The baby that's in the car. You don't get to not consider the baby that's still there on scene as this going. Plus, I got to introduce this. Y'all do some more likes. I'm seeing 165 people liking and 74, 162 people watching and 74 likes. I'm not going to command you to do it. My apologies. I will hold myself accountable because I am not entitled to your like. I am not entitled to your emoticon, whatever, but I am asking you if you can hit that like button because it gets it out to the algorithm more. If you can please do that, I would greatly appreciate it. I had to hold myself accountable. Just because I'm here streaming doesn't mean I get to demand that you like this so that I can continue talking. And creators who do that, shame on you for doing that. Right. Here we go. One of the things to be considered, here's an argument. There is no suggestion that the Chicago Police Department, there is no information, there is no offer of proof to suggest that the Chicago Police Department did a search of Romika Meeks Blackman's vehicle after she got, so when she was shot and taken to the hospital as a part of the crime scene protection and investigation. There is no offer of proof that I have seen yet that shows that the Chicago Police Department did an inventory search of Romika's vehicle. Therefore, it could be suggested that when Romika was forced back into the car, and then after she was forced back into the car by Carlos, her baby daddy, and then she got out of the car prior to QUADAJAH Johnson allegedly or actually going back to her car and grabbing a gun, there is no evidence to suggest that she did not have a gun on her person. Now, of course, we know that she was shot by Holly and that there was no gun on her person, but we're talking about the mindset of the person, Holly, prior to the shooting. And I'm going to give you this hypothetical. For some of you all who don't like my hypotheticals, you don't understand how the Supreme Court or the appellate courts hear the arguments of the litigants. If I am a police officer, which I have been, and I have conducted a traffic stop, and then I walk up to a person, and then I ask them for their driver's license, proof of insurance, blah, 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 and then they suddenly step outside of the car, and then I push them back inside of the car and then tell them to wait. No, you mad. Wait. Get back inside of the car. And they get inside of the car. And then I walk to my car and I'm doing, writing a traffic ticket. And then I'm getting out of the car to then get ready to walk up to their car to give them the ticket. And then they suddenly jump out at me. Sound off in the comments. What am I allowed to assume about that person because I did not search the car? In that hypothetical, what am I allowed to assume about that person because they jumped out at me after I put them back in the car? What is something I did not do to that person or that car to verify that they don't have this thing? I did not search them. I did not search that car. So because I did not search that car, I am allowed to presume that this person could be armed, especially because of the nature in which they got out of the car with this confrontation. So how do we eliminate that? We do an inventory search, and then we document all of the things that are in the car and what's not in the car. That was not done by Chicago police. So because that was not done by Chicago police, that leaves it open for hypothetical arguments, because if the police are allowed to presume that, and the courts have allowed those things to be presumed, that same argument could then apply to QUADAJAH Holly Johnson, who could state that, yes, she was forced back inside of the car, but after she got out of the car, there is a presumption that she could have been armed. After all, she did state that she was going to kill me. I'm not saying it's going to work. I'm saying it's an argument worth floating. I'm not saying it's going to work. I'm saying if I'm defense counsel, I'm floating that argument. And I'm finding cases under the doctrine of stare decisis to throw that out there to say that this presumption has been allowed in previous cases in this jurisdiction. So therefore, I should be allowed to make that argument. Well, this was not a police stop. No, it was not. But take the titles away. The fact pattern of two people in the confrontation and the force science analysis of that, for which I am a force science analyst, that same presumption could be present. So I'm saying this is going to be an interesting case. Let me get to this. Yeah, everybody should have their due process and a right to a fair trial. I don't disagree with you. I agree with you wholeheartedly. I agree with you wholeheartedly. Let me get to this because I want to just talk about the arguments that, this defendant's memorandum in support of an appeal pursuant to Illinois Supreme Court Rule 604H. Now comes the defendant, QUADAJAH Holly Johnson, by and through her attorney, Ari Williams, pursuant to Supreme Court Rule 604H, and respectfully request that this honorable court reverse the denial of pretrial release. The defendant states in following, in support of her request, the statement of facts. I got it, man, look. You said, I wish this happened down south. It wouldn't have been a question, case dismissed, stand your ground. We actually have stand your ground in Illinois as well. We have stand your ground in Illinois. We have stand your, was it People versus Hammond? We have two Illinois Supreme Court cases which give us stand your ground. So we have stand your ground in Illinois. We don't have it by statute, but we do have it by case law. Okay. And so if you had a chance to read this 18-page, so if released, she would have to stay in Chicago. No, she could stay in Illinois. I am almost certain that the defendant in this matter will be allowed to stay in the state of Illinois at a location that is disclosed only to the court, because and if I were Ari, and I'm sure she probably knows best, but if I'm Ari, I'm doing the same type of action that would be done in domestic violence cases where the address of where the petitioner is stricken from the record pursuant to the Domestic Violence Act. I would make that same assertion and make that same request to the court that wherever she stays for her own protection, and you can clearly argue the manner in which don't get me wrong, the family of Romika Meeks Blackman has the right to have whatever emotions they want to have. They have to see, if you follow me, you understand that I talk about this all the time. The difference between how you feel and what you do. You have the right to feel this is BS, Holly should be XYZ. You have a right to all that. But when you have shown a pattern of attacking Carlos, it can be presumed that if your address was made part of the record, that they would find you and attack you, because that is the pattern that the supporters, a percentage of them, have been on. And that is an argument that should be made. So I would probably argue he would be allowed. Okay, moving on. that she would be allowed to stay in Illinois, mandated to stay in Illinois, but that her address not be disclosed on any type of record. And to the family, I'm giving you this advice. Whatever can be publicly looked up, don't live there. Because that's the first place that they would start looking. I'm just saying. Because you know. Don't, we're going to go live at our cousin's house. Baby, let me tell you something. Don't. Okay? Don't. All right? Yeah, I'm just saying. You said she got that part in the bag too? No, please don't. You said, I pray that we hear from Holly in an interview or a book one day. Don't. Ain't nothing special about this to be putting it in a book. Don't. This has to be one of these situations where you take your W for the minute, you go on ahead and be the person who, try to fight this case, whatever the case may be, and see what happens, and prepare yourself for jail too, prison, because I'm not saying she's going to be found not guilty. I'm not saying she's going to be found not guilty. I'm saying it could go either way. What I do see is I see second-degree murder being a possible conviction. I see that. You don't have see. That's why I said I'm fair in my analysis. I'm fair in my analysis. Does the state meet the burden of first-degree murder under 720 ILCS 5, Section 9-1? Yes, they do. Is there mitigation? Yes, a lot of it. So the highest charge I see them convicting on is not first-degree murder. I see second degree. That's the highest. That's the ceiling. That's the ceiling, because in order to get second degree murder, you have to meet the elements of first degree murder, which is there, but there's strong mitigation. And that strong mitigation is this very specific occurrence that occurs between them, this back and forth. And QUADAJAH is not innocent, because I'm looking at other videos of her and Romika and Carlos and Little Los in a motel, and QUADAJAH's on the phone. All of this is messy. So QUADAJAH doesn't look like the perfect victim either. All of this is messy. I would never. All of this is messy. TNT is not the only people who know drama. It's no drama too. This is messy. So she don't look like the perfect victim. She don't look like that. So that's some things that Ari's going to have to overcome, because for sure the state may be allowed to bring that out as an offer of proof to the state of mind. This is messy. And as I talk to you about it in People versus Rodriguez, the justice system kind of considers themselves to be the vanguards of morality. They see that as the vanguards of morality, right? We as a society are not going to sit here. Hold on, I'm gonna read your comments. We as a society are not going to sit here and support NIGGA or hood logic as a part of a reason to claim self-defense, because if we allow you to do it, then everybody else is going to be able to cite this case. We can never allow this to become a precedent. Never. You see what I'm saying? We can never allow this to become a precedent. People versus Rodriguez. That was a appellate case out of Illinois, right? I hear what you're saying, Marita. She said Holly didn't call nobody. I'm not hearing what you're saying, because I got the video. It's in my phone. I got all the videos. People send me stuff. So I got the video of Holly being on the phone. I'm not saying she called someone. She was on the phone. On the phone. Okay. Yes, both were being petty and were with the mess, for sure. Both were being petty and were with the mess. So neither one of them looked like the perfect victim or the perfect suspect, whatever that is. They both were with the mess. Okay. Now, Maria asked the question, if in fact she beats her case, meaning that she is found not guilty at trial, would she be able to get her license back? Yes, she would have some hurdles to climb, but she could get her concealed carry license back. I do know that to be a fact. She can get, because she was acquitted, if she's acquitted, right? Granted, she would have to get the case expunged first, which I would highly suggest before you file for an appeal to rescind the revocation of her license. So I've done those appeals before. So yes, she could get it back. You said petty doesn't equal you threatening my life. On whose side, Reed? You got to give me more context. On whose side? Yes, as far as we know, she didn't call, but she definitely engaged. Oh, that's her voice on the phone, for sure. Okay. You said, now, not when she first gets out, but after this calms down, maybe years later, she can tell her story to help others. My situation happened when I was 27 and now I'm 41. I share it all the time. Okay, congratulations. Yeah, I mean, that's the thing. You're not wrong. You're not wrong. You're not wrong. I mean, and this case is not a special case. This is just pattern recognition. This stuff happens all the time. Denise said, but Mike, let's keep it real. There's a difference in petty, what Holly may have occasionally did, and crashing out, what Romika often and constantly did. That is, yeah, hey. I got Romika's videos of, and I'm gonna sit here and say, you said, am I willing to retrain her the correct way? Hell yeah. But I don't take sides. I am definitely willing to retrain her in the correct way. Because I'm gonna tell you this, whoever her instructor was, those of y'all who've been in my class, you know we talk about conflict avoidance. I don't pull punches. We talk about conflict avoidance all the time. I tell you, hey, you might need to leave your man. You might need to leave your girl. You might, hey, because I'm telling you, she gonna get you in there. And I'm gonna tell you this, you cannot out-train. You cannot out-train a conflict culture. You cannot out-train a conflict culture. You cannot out-train a conflict culture. You cannot out-train a conflict culture that is hell-bent on making sure you'll never let them play in your face. You'll never. When you decide to get this concealed carry license, do you see in this information that was a part of their analysis? What did the court say in their analysis? We have no information to suggest. They don't. Let me find it. Hold on. Sorry about that. Probably should have got something to drink. That's why my voice sounds raspy. But I gotta do this. Here we go. Because I want you to see it. I want you to see it for yourself. I don't want you to believe me. I want you to see it for yourself. Here we go. Sorry about that. It's nasty. I know. Don't, whatever. Talk about your mama. Here we go. Specific factors that the courts are directed to consider in assessing whether a defendant awaiting trial poses a threat are that follows: the nature and circumstances of any offense charged, including whether the offense is a crime of violence, which it was, involving a weapon or a sex offense. Yes, that's considered. The history and characteristics of the defendant, including, here we go, y'all ready? Any evidence of the defendant's prior criminal history indicative of violent or abusive or assaultive behavior or the lack of such behavior. Such evidence, including testimony or documents received in juvenile proceedings. I urge you to get your juvenile record expunged if you got one. criminal or quasi-criminal, civil commitment, domestic relations, or other proceedings. Y'all don't listen to wisdom when wisdom speaks. When you come to my concealed carry class and I sit there and tell you before you apply for that concealed carry license, you need to get your record expunged. Before you apply for that concealed carry license, you need to get your juvenile record expunged. Before you apply for your concealed carry license, you need to see if you got what kind of police reports are against you. You need to stay away from that toxic family. You need to stay away from that toxic man. You need to stay away from that toxic woman. You need to stay away. You need to stay away. When you decide you want to become a legal concealed carrier, there's a lot of people and a lot of things you need to stay away from. Oh man, we're going to go to the club. Stay your ass at home. Oh man, we're going to go to that kickback. Kick your ass back at doggone home. When you decide you want to go the legal route, I'm telling you, the proof is evident and the presumption is great that they are going to look at your record. If you've been committed to Hartgrove because you were never the problem, but your parents' ignorance to your child development was the problem, you need to go on ahead and get a mental health evaluation before you apply. And I got doctors on speed dial that I can send you to so you can get a mental health evaluation so that the proof is evident and that the presumption is great that you are not a danger to yourself or anybody else or the community. Because when you know what's coming, when you start to apply, when you know what the Concealed Carry License and Review Board or the Foreign Carry License and Review Board is going to look at, and I know that personally and professionally, you better listen to wisdom when wisdom speaks. But you don't want to listen to wisdom when wisdom speaks because you focused on whether or not you like me. You focused on whether or not I'm saying something you want to hear. You better listen to when wisdom speaks. Not too many concealed carry instructors in the state of Illinois have been through the stuff that I have been through. They can't teach you from that experience. They don't have it. That's a good thing. That's a good thing. I'm glad they ain't got it. If I had to do the shit over again, there's a lot of shit I'd have done differently. But fuck it, we here. They can't relate to the shit that you in. They spent too much time being the police, putting handcuffs on people they ain't had and put on them, except in training. But I've been there. I've been there. I'm not the only one in my special, but I know what I know. I'm telling you what I know. I'm telling you what I know. You better, these are the records. They are going to go. Come on now, here we go. Here we go. Any evidence of the defendant's psychological, psychiatric, or other similar social history, and that includes social media, which tends to indicate a violent, abusive, or assaultive nature or the lack of any such history. Stay your ass off social media. I'm going to read your question, Maria. I'm going back to you. You asked me, have I ever been sued by someone I trained based on that person causing injury or death due to improperly using their CCW? Nope. I've been in cases, but not like that. No, because everybody who's been to my class and what I put out there, I teach conflict avoidance. I teach conflict avoidance. I teach conflict avoidance. I teach it. Those of y'all who've been through my class, don't I teach the have to shoots versus want to shoots? And in my class, most of my scenarios are what? Want to shoot. Because deep down inside, you want to shoot that. But you got other options. And the other options are what the court is going to consider. Just because you think you were right doesn't mean the court is going to agree. Now, you said Ari will probably get it moved to another venue. I would not be surprised, but I don't know. Do you think moving it to another venue outside of Cook County is going to be wise, given that this is a case of violence? You see what I'm saying? You take this up to Will County, they can't relate to not to violence like that. You see what I agree, Nuri, that would not be wise. Violence. Hey, You take it up to Lake County, you are convicted. You take it to McHenry, boy, we don't allow, you gonna get violence. You may, hey, listen, I don't know. Okay. You might want to leave it in the circuit court of Cook County. You gotta, now you could take it to Sangamon County, but you might get the same outcome too. Hey, this is country down here. You, by God, we don't sit there and take too kindly for you, because the disdain that the rest of the state even has for Cook County. And then you take a Cook County case this popular and take it to another venue where, on the basis of just race alone, you might get convicted just because of that. You got to be careful. That's what happened in the people of the state of California versus Orenthal James Simpson. They found him not guilty, not because the evidence wasn't strong, but because they wanted to pay the state of California and the nation back because of what happened to Rodney King. So they found him not guilty in payback. Not because the evidence wasn't strong, it was payback just because of race. If Mark Furman would have never lied and said, I never said the N-word, that's what turned the case on its head. As soon as he would have sat there and said, yes, I did use the N-word, in fact, very abhorrently. Why? Because I was cultivated that way. I belong to the white culture, but I have since learned that that was a horrible thing to do, and I have since learned better. The jury may not have liked it, but they wouldn't have called him a liar, and then they could focus back on the evidence. But he chose to lie. That's what killed that case. You already got what happened to Rodney King. You already had other previous racial injustices, and now you got a lying white cop. Burn him. That's what got OJ off. And Johnny Cochran said, this is manna from heaven. Oh, you couldn't have bought this. And F. Lee Bailey, a wonderful trial attorney, was the one able to invoke that out of Mark Furman. It couldn't have been Johnny Cochran. It had to be white on white. You got to learn how to use your trial strategy. And even Johnny Cochran had to learn that when he went down to North Carolina to try to get the tapes that proved that Mark Furman used the N-word. That gratuitous alliteration that you are saying down here in North Carolina that works in Los Angeles County don't work down here in North Carolina. I don't know if you know this, Mr. Cochran, but take a look. You don't play as well in Dixie. We're going to file an emergency appeal to the appellate court in North Carolina. Let me argue it before the court. And F. Lee Bailey was able to argue before the court, and you put a white man in that place who's able to argue better than you, and they got those tapes. Now, you said, I think the trial is going to be fair. I think it's going to be hard to find jurors in Holly's favor. I don't know. Because I don't know if I agree. I mean, I ontologically respect your opinion. Your opinion has validity. I just don't know, because this is a case where you've got mother on mother. You got mother on mother. You see what I'm saying? We can't sit here and say Khadijah isn't a mother. We got mother on mother. And this is drama. People are interested in the self-defense argument and you talking about Cook County. Cook County is huge. I don't know. I think you're going to find some fair jurors in Cook County. I don't believe that you're not going to find some fair jurors in Cook County. It's going to be a stretch. It's going to be a stretch. I think you can find some fair jurors in the circuit, in Cook County, who would be able to see both sides and argue the case. Yeah, you know it. Marsha Clark. Hey, you got to go get her book. You ain't got to go get it, but I suggest you go get her book. She talks about that. She's an amazing author, and it's an audio book too. It's an amazing book. What is it called? trying to get it. I like suggesting books to people who read. Don't get mad because I said that. You know, people get mad at everything I say these days. Oh, it's called Without a Doubt. Yes, right there, Without a Doubt. That's an amazing book. An amazing book. You said, in the simplest terms, seeing a woman attack a woman while she has her baby, Cook County mothers don't play that. A lot can go in Holly's favor. Yeah, I agree. I agree. That's why I said this is going to be a very interesting case. It's going to be a very interesting case, and I'm glued to it. Everybody was like, they're not going to let her out. And I even floated the possibility that they possibly weren't going to let her out. But if you read what I wrote, the second two prongs, I was like, I don't know, that can be argued. And I even said, Ari did a great job with her arguments. Man, you got to read that 18-page argument where she went line by line and found evidence to show. She didn't just make arguments. She's got evidence, which means she's got some great defense investigators. Damn, I want to be on that team. Just generally, but I want to be on that defense investigation team. She got some great defense investigators who were able to find. This witness was on the bus with some headphones, some whole Beats by Dre. You sitting on the doggone 20-second. You ain't hearing shit. Talking about some, I heard them say. Boy, you know that CTA bus got cameras? You on a 22nd Clark bus going eastbound. Ain't no way you. You ain't hearing that. You got a whole witness who said, I saw it from the green line all the way that. Boy, you don't have no ant vision. Boy, you don't have. You ain't seen shit. Boy. And you on the bus. Bitch. Come on, man. You ain't. And that's what happens when you witness something where we see you on them big beats. Come on, boy. You know it's easy to say. Y'all like you ain't witnessed it. Come on now. What you saying? Witness 3 had to take her headphones off to talk to the police in front of her, but she heard and saw everything. Come on, man. Matter of fact, y'all sign off in the comments. I got it right here. I'm trying to make use of y'all time. I ain't got nothing but time. Y'all want to go over each argument in there? Sign off in the comments. Sound yes. If you want to go, I ain't got nothing but time. Time and electricity. I may have to order my food and get me a sippy sip. Moisten the soup coolers. Yeah. About some, when you see me and you try to see what's up, ski. You ain't what ski. You ain't witnessing shit. You ain't boots. All right, let's go over the arguments. Stupid shit. Let me download this. That's my beat, y'all. You said Ari showed so many. You said Ari showed so many ways it isn't convincing and can't be deemed non-credible. Yeah, we're gonna go on ahead and look at it. Let me see if it showed up. Let me pull it up. Don't laugh. Ski. You ain't sitting here, boy. I saw shots fired. Ski. What if you was having phones? What if you was looking at something? You was looking at some. Oh yeah, I got something to show you. Oh yeah, what is it? I'm gonna show you this. And then all of a sudden you look up. Boy, you ain't seeing no fight. You got balls on the map. All right, let me stop. I'm just saying that investigations tend to prove certain things. You don't always have the shit on your mind you think you do. You trying to get some other ski. told you I don't fucking play. I'm an idiot. I'm a fucking idiot. When you see me and you trying to see what's up, ski. All right, let's get to it. You said she knows what she's doing. She get high props. All right, let's get to her. All of a sudden, you sitting here talking about some should be crying, but I just. What the hell is going on? Oh, man. All right, let's get to it. I got it on the screen, y'all. When you see me and you trying to see what's up. All right, here we go. All right, so here we go. This is Ari Williams, and her appeal. Here go her. You said, Mike, stay focused. I read the appellate court asked the circuit court to reconsider. So does that part start the pretrial over? Yes, it does. They have to do the pretrial detention hearing over again to reconsider. That's what reverse and remand means. They have to do that hearing over again. Now, whether or not the litigants, being the state and QUADAJAH's attorney, Ari Williams, have to re-argue, that's a question. But I do know they have to have hearings pursuant. You said Ginger shot on me? Say less. Matter of fact, hold on 1 minute. I'm going to show you what I got because it's in the car. Because I got to drink that. When you see me and you try to see what's up, ski. Don't laugh at me. When you see me and you trying to see, I had to go grab this. Gotta wet the whistle. Hold on. Y'all, I'm stupid. I had to run to the car because this moment is sponsored by Health Aid Kombucha, ginger and lemon, bubbly probiotic tea for a healthy gut. When you see me and you trying to see what's up, ski while on the 22 Clark bus. Here we go. You said I felt that way. All right. I felt that way. Illegal to keep her life locked up when she had no criminal history and was not the aggressor. That's correct. That's why if you're going to lie, make sure it's no evidence. You lying that can make them call you a liar even more believable. You said try synergy. Come on, look at y'all giving me okay. Okay. You said it's healthier? Okay. Well, I'm about to kill this unhealthy, healthy stuff. Okay. All right. I appreciate you, though. I'm going to try it. Here we go. Let's get to it. Let me get this comment up here. I'm sorry. Thank you, Tamika, for that. I appreciate you. Here we go. Ari did her big one on this one. Now comes the defendant, QUADAJAH Holly Johnson, by her attorney, Ari Williams, pursuant to Supreme Court Rule 604H, and respectfully request that this honorable court reverse the denial of pretrial release. The defendant states the following in support of her request. Here are the statement of facts. Excuse me. In December of 2024, Ms. Johnson sought a stalking no contact order against the deceased. You could have, why you had to call it the deceased? Why you? All right, Ari. We normally call him the decedent or the victim, but I guess deceased. All right, I get it. Cool. Here we go. Against the deceased, alleging that numerous threats were made to Ms. Johnson herself and through Ms. Johnson's family members. Now, all these that she has are exhibits, right? Ms. Johnson was pregnant, or the record, page 5, 24. Got it. Page 5, line 24. Ms. Johnson was pregnant with her first child throughout her active seeking of the order, having appeared at each scheduled court date. On June 18, 2025, both Ms. Johnson and the deceased appeared via Zoom to address the issue of whether the order would be granted. I wish you would read that transcript. That's entertainment right there. Here we go. On July 14, 2025, Ms. Johnson was granted a default order of protection, which this kind of default no context talking order, same difference, after the deceased failed to appear in court over Zoom pursuant to the record 142 through 143. Although the default judgment was entered and the deceased may not have been formally served, the deceased was aware that an order of protection was being sought against her. Now, that can be an argument because just because she was not served with it doesn't mean you don't have knowledge of what orders of protection do. There's a difference between knowledge of what orders of protection do and the order of protection having the force of law. Both can be argued. Okay. On December 8th, 2025, at approximately 8:56 a.m. Hold on for a minute. I'm just thinking about something. I have to go back and read the record. Whether a temporary order was granted and a default order was allowed. Because if a temporary order was granted, then she wasn't supposed to be in contact. I don't know. Okay. Anywhere. I'm just thinking about things. Excuse me. All right. On September 8th, 2025, at approximately 8:56 a.m., Ms. Johnson and witness one, who are in a dating relationship, left witness one's home on the 2100 South block of State Street with their 6-month-old child after spending the weekend together. You probably should not. Okay, whatever. All right, moving on. Witness one's black Mercedes-Benz left the alley near his home at 8:56 a.m., making a left-hand turn onto State Street and then a right-hand turn onto Cermak, parking parallel in front of Ms. Johnson's parked black Chevy Cruze on 20 West Cermak. Ms. Johnson and witness one removed their child from the Mercedes-Benz and secured the child into Ms. Johnson's Chevy Cruze. Between 8:51 a.m. and 8:53 a.m., the deceased dropped off her 6-year-old child in common with witness one at a school located across the street. At approximately 8:57 a.m., the deceased was captured on video driving a white Kia sedan eastbound on Cermak, promptly making a U-turn on Cermak. The white Kia traveling westbound on Cermak continued towards Ms. Johnson and witness one's parked vehicles. The deceased double parked her Kia on Cermak behind witness one's vehicle. Ms. Johnson's vehicle was blocked by witness one's vehicle and the deceased vehicle. At approximately 9:02:29 a.m., a call was made to 911 by an unknown caller. The caller described 2 black women hitting each other across the school on 22nd and Cermak. Though interrupted by the 911 dispatcher, the caller mentioned there's a black lady. She seems to be the aggressor, but the woman in the green has the gun. Records.
50th Law with the great Robert Greene.
Oh, sorry, that was 50 Cent. Records. You said I have to read Ari's response to the appellate memorandum. Okay, I got to read that. There was a fight that ensued between, the woman in the green was Petitioner Johnson. She was wearing green tights at the time. Here we go. There was a fight that ensued between Ms. Johnson and the deceased after witness one moved his car. The deceased continued to run. Is Carlos' dick that good to where they fight? Y'all know I had to end. I don't want to know. I'm just saying people will fight over some good dick. All right, here we go. The deceased continued to rush Ms. Johnson when Ms. Johnson shot. Ms. Johnson remained on scene after the shooting as a part of the record, page 10, line 138. Ms. Johnson lawfully owned the weapon. Ms. Johnson's lawfully owned weapon was recovered from her vehicle. There were 3 spent shell casings. Look at Saucy Santana. Hello. I'm just saying, people. All right, moving on. Ms. Johnson was detained. She was a valid concealed. Why? Come on, Ari. There's no such thing as concealed to carry. Y'all please stop calling this concealed to carry. Y'all still, come on. Y'all still, hey, I gotta say, Courtney Lachey, you are not wrong. I gotta highlight your comment. I got to highlight your comment. I had to step away from this case because the way they were doing Holly wasn't right. We see bullies like Romika every day in the Black community, and Holly asked the courts for help. This is why I'm going to be partial to Holly on this. Romika Meeks Blackman's family, if you're watching this, hey, you just going to have to be mad. Multiple things can be true. Romika should have kept going. She should still be alive today. But let me tell you something. Bullies like Romika are in the Black community. And just because you popular can fight and you're popular and you wear all the latest clothes and say all the latest lingo and you know how to footwork. And I'm going to tell you this, I was a lame as a kid. Lames love living. And a scared person will shoot you faster than somebody who will fight you. Y'all better learn to stop playing around and stop bullying people. Because we getting tired of your shit. We getting tired of it. That's why we got the problem in Chicago that we got now. Because too many of you are doing shit because your parents fucked you up as kids. That ain't our fault. No, we don't wear Jordans. Yeah, we do wear Pro Wings. Why I sound like I'm revisiting my childhood? No, I can't do no footwork because I used to try to do that footwork and I couldn't. My right leg wouldn't. Anybody who can footwork, I'm jealous of. I'm jealous of. All I can do is, and that's it. I just got one. I can't do the rest. I can't do the rest. My Pro Wings wouldn't lift me up. They wouldn't hold me down. The rest of y'all was wearing Jordans and what? We didn't do that. What? I could. That's why I held up the wall. You wouldn't invite me to the soccer. We had that back in the day. I'm an 80s baby. So I was a lame. I went to the thrift store. That's where I got my shit from. Thanks, Mom. Love you. And I love that to this day because I'm not materialistic. So thanks, Mom. I'm just saying that. You see what I'm saying? My thing is, you said Holly was bullied, though. She was going head to head with her. She antagonized. You said Holly was or Holly wasn't. You said Holly was bullied, though. She was going head to head with her. She antagonized the situation, and Carlos played a part as well. It was all childish behavior. Yeah, because sometimes the person who isn't the bully then becomes the bully, but sometimes the person who is the bully then plays like they're not the bully. And you see how this all fucking messed up? You see why I don't like shit? Because it's all messed up. It's all messed up. But I'm just saying, y'all, we got to have a conversation about, I mean, I don't want to know, but y'all be real with me. Sign off in the comments. How many of y'all went crazy over some good pussy? Come on, man. I'm talking to the guys. Y'all get some more people in this conversation. How many of y'all went? Don't do me. I got clients. Don't lie to me. You know you went crazy over some good pussy. How many of you ladies went crazy over some good tea? Come on, boy. Don't. You was like, let me see it. He yoga matted you. He pulled out the yoga mat. Oh. And what I'm saying is, if you are not disciplined in that space, you're gonna do some crazy shit. It's not the, well, I agree, Saucy. Saucy said, I ain't never killed over it. Shit. I ain't never killed. But you see what I'm saying? Hold on. You said we don't know that. You said that wasn't self-defense. I don't know. That's why we going to trial. I'm just saying, you said we don't know that. We see her in Carlos. How do we know how bothered Holly was too? Holly was probably from the window to the walls, to the sweat drip down. All these. Come on, I agree. I don't get the reason why she made a U-turn to approach them. I'm pretty sure it wasn't to say hi. I'm pretty sure it was one of those, that's my dick. Come on. Don't act like this stuff doesn't happen. Don't act, come on, man. Does it make sense? Oh, come on. Just because it don't make sense to you don't mean it don't, right? People will do that. You got to be in the courts to see it. Go to 555 West Harrison and see it. It's happening all the time. You said verbally, but never physically. I have physically attacked the man because he was the one I was dating. I started with because he allowed it to happen and to blame, not to other women. So I beat his ass. Okay. I appreciate you for being honest, Adrian. Oh, I think when Romika finally saw them together, I think she lost it. She reminisced of the time when they went to Acapulco, Mexico. I'm not saying they went there. And they had some drinks. And he was North Carolina, raise up. I'm just saying, he got a type. They both small. You probably threw them up, twisted them around, slathered Astroglide all over the place. It was a slip and slide. Y'all not, okay, let me stop. All right, y'all see, we're not having, see, if we're not willing to have some real conversations, then what are we doing? You said the U-turn wasn't the problem. It was stopping and getting out of her car. I would argue the U-turn is part of the problem because you need to get away from that same street. Because guess what? You make that U-turn and keep going, you could then turn around and come back. Or you could back up. Like, you could do some crazy shit. How about you see it and just move on? But it's hard for people to do that. It's hard for people to do that. Yeah, it is. It is. Repick said, I would pick up every sand off Lake Michigan before I'm sorry, I'm not approaching no woman over a man. Too many fish in the sea, too many fowl in the air, too many beasts in the field, on the beaches of jet black sand. Jet black sand. Netta Williams said, motherfuckers think they have a baby by somebody they think they own them. Shit's crazy. That's a thing. And notice, these are the people commenting in these comments who the jury could be selected from. That's why I said Cook County is the venue where you want to have this case, because you need people with real experiences. You need people who understand. You know where I got that from. I got that from the Bible. The U-turn was definitely the problem, because if you're not invited somewhere, you should keep going. Believe it or not, the pull-up will be the deciding factor. She didn't make that U-turn and left that car in the middle of the road and jumped out for nothing. That shows how angry and pissed off she was. That's going to be a factor. Let's get to this, because I said I was going to stay live so that we could talk about the issues that Ari talked about. Here we go. Witness one. Witness one stated to police on scene that the deceased ran up on Miss Johnson, told her, I was going to catch you, and swung at her. He also relayed to police that Miss Johnson told the deceased to leave her alone. I want to copy the text. Move. That's witness one. Here we go. Witness two, a DoorDash driver drove eastbound on Cermak, allegedly observing Miss Johnson, witness one, and the deceased on the street where Miss Johnson and the deceased were seen arguing. He was unable to hear what was said by either party. Here we go. Witness two further alleged that witness one was standing between Miss Johnson and the deceased with his arms extended, that Miss Johnson advanced towards the deceased, and witness one pushed Miss Johnson away while the deceased stood with her arms crossed. Witness two was at a coffee shop when the shooting occurred. Oh my God. Oh my God. Witness two said all these things. but witness 2 was at a coffee shop when the shooting occurred. Was you there or was you not? Is we finished or is we done? Come on. Witness 3. Witness 3 was sorry, let me read this right. Witness 3 is one of the only individuals that alleged to have seen the entire incident. At approximately 8:57 a.m., while the deceased was making a U-turn on Cermak, witness 3 was in Chinatown traveling on an eastbound bus. Her window was the closest to the north side where Ms. Johnson, witness 1, and the deceased were located on Cermak. The bus window was closed. Bus footage also showed witness 3 wearing thick headphones. Now, she might not have had the AirPods. She might have had the Air Muhammad's. Okay, now don't get mad at me when I said, buddy, look, this is not the AirPods, but this is second rate. You will never find these anywhere, nowhere. All right, that's wrong. Community, forgive me for saying that. But you know I'm just repeating patterns of what I hear. Buddy, listen, you will never find the cards anywhere. I tell you, this is not the AirPods, but this is Air Jordan. This is, all right, don't laugh at that shit. Moving on. She was wearing Beats by Gary. She wasn't wearing Beats by Dre. She was wearing Beats by Gary. Stick. The bus on Cermak was approaching State Street. But bus footage captured witness 3 turning her head to the left to observe the incident between Ms. Johnson. Oh, I'm sorry. I've got to blow it up. Here we go. Between Ms. Johnson, witness 1, and the deceased. At the time, the deceased white vehicle was seen on the bus footage with the driver's side door open. Witness 3 told officers that she saw witness 1 pushing the deceased into the driver's side door frame and slamming the door on her. Witness 3 only observed the incident for 10 seconds before turning around, not making a frat or a phone call. Witness 3 then got off the bus with her baby stroller and began walking eastbound on Cermak, away from the incident and a few feet away from State Street. The bus stop is approximately 350 feet away from where the shooting took place. At 9:02:24 a.m., Beats by CTA. Witness 3 called 911 to report observing, quote, a fight breaking out with a white car and black car, 2 black females, ellipses, end quote. She also reported witness 1 pushing the deceased into the driver's side door frame and slamming the door on her. After getting off the bus and walking away from the incident, witness 3 spun her stroller around. At 9:03:16, a pod camera facing northeast at Cermak and State intersection captured witness 3 crossing the east side of State Street, walking northbound, with the incident occurring on the west side of witness 3. Witness 3 was facing northbound. Thank you. If they called back to back, how did witness 3 even see Holly getting the gun? Do y'all? Oh, come on, man. Come on, Lord. Ari got a great defense investigation team. Once witness 3 crossed the street, she was captured on pod camera under the CTA green line, where she walked far enough north behind a building to have obstructed any westbound view of the incident occurring between Miss Johnson and the deceased. Had witness 3 walked southbound towards State Street and turned right to observe the incident, the pillar for the transit authority still obstructed her view. The pod footage revealed witness 3 run from behind the building where she and other bystanders are looking to the west of them on Cermak. It was at 9:04:55 a.m. where witness 3 called 911 a second time to report the shooting. According to witness 3, after her first 911 call, the deceased entered her vehicle. She alleged that Ms. Johnson approached the deceased vehicle making threats. Witness 3 alleged observing the deceased exit the Kia and get placed in a chokehold by witness 1. Witness 3 further observed Ms. Johnson allegedly go to her vehicle, retrieve a gun, and stand on the sidewalk. Witness 3 alleged the deceased broke free from the chokehold and took steps away from Ms. Johnson while Ms. Johnson pointed the gun at the deceased. When speaking to investigators the day of the shooting, witness 3 alleged that there was a pause after the first shot and subsequent shots. However, she told officers on the scene that the shots were successive. Y'all see, come on now. Witnesses witnessing, but forget in 2025 and 2026, you got cameras everywhere. Witness 3, she also claimed that witness 1 and Ms. Johnson fist bumped after the shooting, though this was never stated to officers on the scene. It was also not until officers were on scene that witness 3, hello, is this mic working? Had to remove her headphones to hear what they were saying. What the hell was she hearing? Oh, well, hold on now. This is witness 3. So witness 3 is mi corazoncito está luto por tu amor. What would you listening to? No es una novela, es una novela. Está yo, corre, corre, no, es una novela. Está yo, corre, corre, la. Oh, what were you listening to? Descontrol. What were you listening to? Oh. Oh, I'm not, all right. Witness 4, the school crossing guard, was walking east on Cermak approaching State Street. He alleged that the deceased was unarmed with a hand in the air. Sorry, you can't read that. Here we go. Hand in the air, tried to break free from witness 1's grasp. Witness 4 turned away from the incident while shots broke out. When he turned around, he saw Ms. Johnson with a black handgun in her right hand. Witness 4 identified Ms. Johnson as the shooter after assuming that because she had a gun, she must have fired the shots. This good day, y'all. Oh Lord, me's dying and forgot they gon' have to testify before Jesus. Why? You get what I? Oh, you. Come on now. Here we go. Let's get to witness 5. It is alleged that witness 5 was in her car and then watching from her workplace on Cermak when she saw the deceased and Ms. Johnson arguing over the witness 1. She alleged that the deceased was not aggressive and that Ms. Johnson was charging at the deceased, prompting witness 1 to grab the deceased to stop the fight. Witness 5 alleged hearing Ms. Johnson state she was licensed to carry. Witness 5 claimed to hear 4 shots. Here we go. Let me get to some of this. She cites People v. Morgan, independent de novo review. The appellate court did that. State failed to prove by clear and convincing evidence that the proof is evident. The presumption is great. You said that can the courts now stop her release? No, the courts can't stop her release. If the appellate court reversed and remanded it, they have to act pursuant to that unless they appeal to the state Supreme Court. I don't usually see that happening. This isn't that serious. This ain't that serious of a case. This, y'all know what I'm talking about. Like, there's way more. The kids who were shot and deleted, I've been saying killed all this time. Why now? The kids who've been shot and killed in North Carolina, that is a heinous case. This is not heinous. This is not heinous. This is law and order, criminal intent. Maybe law and order SVU. Maybe regular law and order. This is in the criminal justice system, all offenses. You see what I'm saying? This is what this is. This is not that special. I mean, don't get me wrong. Rest in peace. My condolences. But this is not, this is not that. And yeah, this case ain't going to the Supreme. They're not going to even waste their time on that. They're just going to release her, give her conditions, and then see what happens. That's what's going to happen in this case. It's not going to be that. It's not going to be that. All right, y'all. It's 12:39. I'm hungry. It's lunch. Y'all want me to go back live and talk about it again tonight? Because I know I can get some more people watching it. I mean, well, no, but hold on now. This in the criminal justice system, sexually based. Well, I get it. I'm gonna go back live and talk about it tonight. Please state that explicitly in plain language. Content creators are lying. Well, of course. Look, everybody has the right. You say what time? Do you have a client tonight? You said save this live. I'm gonna save it, but I'm gonna go. You said I don't see this going to trial. I don't know. I hear you. I see that it has to go to trial. This case has to. This case cannot not go to trial. Let me give you the time. Y'all put down a time. Put down a time y'all think I should go live. I got time. Y'all put down a time y'all think I should go live, and then if I see the majority of the times, I might make a decision from what I see. 7 p.m. 7:30. This case has to go to trial. This case has to go to. Okay, I see. You said not too late. Hey, you said 7 or 8. I think 7 o'clock would be a great time to go live on this. 7 o'clock p.m. Central Standard Time it is. So tell everybody they want to come on back. Look at you, Regina, 8 p.m. All right. So I'm going to go live. How about this? How about 7:30? Can we agree on 7:30? We can agree on 7:30. Because how many of y'all know the older you get, you go to bed early. Y'all know, hey. How about 7:30? Y'all think 7:30 is a good time? Yeah, I think 7:30. Yeah, 7:30 Central Standard Time. Then we're going to go live and we're going to talk about this again. I got no problem breaking it down for the friends. Yeah, the sooner you get it, Maria. We going to bed early. We need our sleeps. You remember all the time your mama told you to go to bed? No, I'm not going to bed. You paying for it now. You paying for it now. All right? You paying for it now. Yeah, but I'm not worried about the other content creators. They got their angles as to why they are doing things. But I try to make mine fair and balanced with a little bit of slash of bias and humor because I'm human. I'm partly Free Holly because she got a right to fuck. If she want to fuck her life up, and I'm not saying she's going to do that, but come on now, we got to talk ontological respect. Ontological respect is respecting a person's existence and right to be without any opinion for their life choices. If she want to be with Carlos, a man who has another baby by another woman, that's her right to choose. That's her mess to get in. Does that make sense? She got a right to make that choice. But I was not happy that Romika pulled up on her. Hey, anybody else might have upped that thing and might have drawn down. Ain't nobody got time to be playing around with y'all. And especially if you know that you don't have that Mouseketeil on you, that pum pum. If you know you don't have that pum pum, you shouldn't even be pulling up on nobody in Chicago. Because nowadays people they're not fighting. You called Holly a scared bitch. Scared people will shoot you faster than anything. They're not thinking about the law. They're not thinking about a fair fight. They're going to body you. And that's why this has to go to trial. This has to go to trial. This has to go to trial. Romika, you're not wrong. Romika had a sense of ownership of Carlos. A lot of first baby moms have this mentality. It has to change. You ain't wrong, Denise. That's what I did. You heard her say it in previous videos. He got a family over here. He got to take care of things over here. The proof is evident and the presumption is great that she was definitely the antagonist in this. And people don't like bullies. She even bullied Carlos. Does she deserve to be alive? Hell yeah. Should she have mind her fucking business? Hell yeah. You pulled up on them. What did you think was going to happen? Yeah. All right, come back at 7:30. You said I'm going to ask you the last question. Where do Carlos being the cause of all this at? Well, as well, Holly not innocent. She provoked Romika. Please don't pay that card. Girl, go. Get out of here with that shit. Get out of here with that. Get out of here with that. I'm not saying Holly was innocent. It was all messy. It was all messy. I can appreciate you separating the H in that, Takaya. Thank you for that. That murdering itch going to prison. Thank you. I appreciate you, sir. She might be convicted of second-degree murder. You missed that part. If Ari is able to get Holly acquitted, she already popular, but she definitely gonna be overpopular. She definitely gonna be overpopular. Do I see it? I don't know. I don't think so. I think the highest charge she gets convicted of is second-degree murder. Even though she's not charged with that, that's going to be a lesser included. That's going to be a lesser included. Because this case meets the elements of first degree, except there's mitigation. I see second degree the highest charge. I see that. I'm not saying it's going to happen. I'm just saying I can see that. This is just like Jason Van Dyke. Jason Van Dyke was the person who shot and killed Laquan McDonald. 16 shots in a cover-up, to remind you. Right? 16 shots in a cover-up. He thought that what he did was the right thing. State charged him with first-degree murder. The jury convicted him of second-degree murder. Why? Because there's a statute within that provision, 720 ILCS 5, section 9-2, where the person may have thought they were doing the right thing, but the law, the facts, and circumstances show they were not. There's mitigation. There's definitely mitigation here. There's definitely mitigation here. Definitely mitigation. So the highest thing I see her getting convicted of is second-degree murder. I don't even see manslaughter. I'm going to do some more research. I'll come back with that at 7:30. Manslaughter is possible. It is, but I don't see it. It's possible. It's possible. And I'm willing to be wrong. I could be wrong. I could be wrong. I could be wrong. Yeah, I could be wrong. You said she not completely free. No way. It's a long road ahead. So please don't rejoice so soon. The big house joint waiting for sweet Holly. I used to be a corrections officer. Boy, y'all are something else. Prison don't work like that, especially in Max. I used to be a state corrections officer at a Max prison for both men and women. There was one person who was in there who was convicted of killing her baby and doing things to the remains and feeding it to her boy. They did not do anything to her, and she was on death row. And then they commuted their sentences. This is when Governor George Ryan got or dealt away with the death penalty. And now we got life in prison. They didn't do nothing to her. Jackie Montanez, I was there when she was there. They didn't do nothing to her. Malero, when she was there. I know so many names. They didn't do nothing to them. So y'all be lying about shit you don't even know. You be lying about stuff you don't even know. That's that type of stuff. That's what you think goes on. You ain't never been inside the walls. The lifers be some of the most nicest ones you could think of. Now, of course, it depends on what correctional center you go to. But the lifers be the nicest ones until you get on that bad side. The penitentiary got something for her. Get the fuck out of here. That is not gonna happen. Y'all just say shit. You might find they may protect her. Weirder shit has happened. Same thing in the men's prisons too. Same thing in the men's prisons. You're right. I should keep my mouth closed. You totally right. Let me do that and block your goof ass. Let me do that and block you. Where you at on Facebook? Let me go on ahead and let you know. Let me put you in purgatory. Yeah. Let me put you in purgatory. Let me go ahead and do that before I sign off this live. Same thing for you, Takaya. Yeah, why have you here? Go ahead and do that. No, I ain't worried about how he support us, but I definitely don't have to have him on the page when I don't need to. You follow? Block this, not block this, but mute that. Y'all can still hear me, right? Yeah, I can block that weirdo. I ain't got time for that shit. Got it. That's the only way to get rid of them. All right, cool. And this don't get me wrong. If you are a Romika Meeks Blackman supporter, I don't have a problem with you being over here. This is a very fair community. This is a extremely fair community. This is a fair community. Chanel and I had a disagreement about some shit. I don't have a problem with disagreements. It's your manners. To me, it's always manners. I don't have a problem with you having a disagreement. I love disagreements and arguments and questions and stuff like that. But I don't, you see what I'm saying? I don't disrespect the platform. You can disrespect me. I don't care. I know who I am. But the platform, and now ain't got time for that dumb shit. Yeah, we ain't got time for that. Why you got 36 friends and your fake ass profile and your name is Tierra, but it says his. It's a whole fake profile. AI shit. Let me go ahead and send you where you belong. I don't care about disagreeing opinions. I love them. Yeah, disagreement don't get you blocked. It's your manners or the lack thereof. You know what I'm saying? So we took care of them goofy asses. Are we looking for evidence, or are we going off of the law, or are we going according to emotions? Are you asking me this, Latrice? Well, you right, Jada. You right about that. I hate when they have to be blocked due to weird behaviors. Now they're not gonna learn shit. But guess what? Arthur Schopenhauer said it best. It's not that they won't understand, it's that they can't. Some people are at the height of their cognition. What does that mean? Since they're at the height of their cognition, that means that they're at the height of their mental processing capabilities, and nothing that you say they won't be able to register it. They won't be able to, it won't make sense. So then you'll find yourself arguing to a brick wall. You'll find yourself arguing to a brick wall. And how many of us do that? You find yourself arguing to a brick wall. Let's not do that. You got to learn when to walk away from arguments. You got to learn when to walk away from ignorant people. There are some stupid fucking people out here, and stupid by definition simply means having or showing the great lack of intelligence. Ignorant just means you generally don't know. I love ignorant people. What I can't do is violent ignorant people. Can't do that. There's levels to ignorance. There's ignorance, there's stupid, and then there's just fucking dumb, which is stupid squared. Yes. And you got to know how to discern who you can talk to and who you can't. So I love blocking. In fact, you got 5 love languages: physical touch, acts of service, words of affirmation, gifts, quality time. You got 2 more: walking away and blocking motherfuckers. I am a huge 7. Please. What? You got to. Okay. All right. Let me go get something to eat. Got something else to do. Come back 7:30 p.m. Central Standard Time right here. This is a Structure Mike. I will see y'all. Thank you for all y'all that came through. I'm going to leave this up so you can watch the replay. Okay. Look at you, Team 7. Hey, you see what I'm saying? I'm going to come back here at 7:30. 7:30. Okay. We're going to come back here at 7:30 and we're going to talk about this again. Bring something to drink. Don't get drunk, but bring something to drink. All right, sip you something. Bring something back to drink. And I'm trying to find that other kombucha that you said so that we can have that conversation. Yeah. All right. Until then, do I have my outro video? Yeah, let me set my outro video up, put it on there. All right. Let me go on ahead and play my outro video. And then we'll be back at 7:30 p.m. Central Standard Time. This has been Instructor Mike. Oh, by the way, here we go. Some of y'all asked me. I'm going to tell y'all this. Those of you all, I got a concealed carry class. I got concealed carry renewal classes. I got a concealed carry class. I got concealed carry renewal classes. What is that coupon code that I said you all were going to get if you all came in the live? Let me look it up real quick. I want to give it to you because you would get 50% off anything on my website just because you were in the live. Just because you were in the live. My website is www.securityjobschicago.com. www.securityjobschicago.com. Anything on my website, and I mean anything on my website. Any security class, any concealed carry class, any concealed carry renewal class, any class. Any class. If you put in the code live 2026, live 2026, I just put that in the comments, live 2026, you could get 50% off whatever you want on my website just because you came in. I got a concealed carry renewal class. Come on now, you catching what they say in the streets, you catching the stain. I told you I'm a lame. I don't know the fucking terms. You catching the discount. You can get the whole package. Unarmed armed fingerprints per card. Normally it's $300. Put in the code, it's $150 just because you watched the live all the way to the end. Just because you watched the live all the way to the end. Live 2026. Okay, you can go to my website, securityjobchicago.com. Securityjobchicago.com. You ain't gonna, man, look, when you know your word, I just want to help you get somewhere, grab some licenses, do some things. Live 2026. That's the code. All right, y'all. See you at 7:30. See you at 7:30.
What's going on, you? This is Instructor Mike. You can follow me on Facebook at Mike Brown or Instructor Mike. Follow me
It
on
could be you as a citizen, and you walked up and you see somebody. Look heavy? I don't know. Create special, that must be. But it's good to know that this can handle the high pressure rounds of the flooding. Ready to go.
Make eye contact with me. He's still trying to get it open a couple of times.
Show tail.